The Senate Committee on Civil Rights, Judiciary, and Public Safety is called to order. There being an absence of a quorum, which we will have in 10 or so minutes, I believe, we will actually proceed directly to the business of the meeting agenda, and then we will come back to the roll call and other business. So first we are going to take up Senate Bill 599 from Senator Geiss around medically frail parole. Senator Geiss.
Had a little traffic jam there. Good afternoon, members. Thank you, Chairwoman Chang and members of the Senate Standing Committee on Civil Rights, Judiciary, and Public Safety for hearing Senate Bill 599 today. This bill is the result of several groups working together, including the Department of Corrections, American Friends Service Committee, also known as AFSC, Safe and Just Michigan, and other individuals and organizations in this space to address our state's medically frail parole law. Several are joining us here today for testimony as well. Now, while the law itself is good, there are provisions in it that significantly hamper its utilization. In fact, since its implementation, I believe only one person has been able to be granted medically frail parole, despite the percentage of aged and medically frail population serving sentences in Michigan Department of Corrections facilities who otherwise could be eligible for medically frail parole. PA 13 of 2019 included the following language, and that's the PA that most recently updated our medically frail parole law. The parolee must only be placed in a medical facility that agrees to accept the parolee and that is agreed upon by the parolee as described in the subdivision, which references the section. However, the limited number of medical facilities that are willing and able to manage and house this specific population leads to fewer otherwise eligible individuals receiving medically frail parole. Our revision strikes the limiting language and addresses additional conditions of agedness, infirmity, and disability so that if an incarcerated individual otherwise eligible for medically frail parole is able to be paroled to a location other than solely a medical facility, not limited to be placed with their loved ones in a home setting. The individual's placement would still need to be approved by the parole board, and the term medically frail will still describe an individual who is a minimal threat to society as a result of the individual's medical condition, who has received a risk score of low on a validated risk assessment, whose recent conduct in prison indicates the individual is unlikely to engage in assaultive conduct, and who has one or more of the following: a permanent or terminal physical disability or serious and complex medical condition resulting in the inability to walk, stand, or sit without personal assistance. We have also inserted that the term medically frail includes an individual with a terminal medical or mental health condition resulting in a life expectancy of under 12 months, a permanent or terminal disabling and mental disorder, including dementia, Alzheimer's, or a similar degenerative brain disorder that results in the need for a nursing home level of care and a significantly impaired ability to perform 2 or more activities of daily living. Passing Senate Bill 599 will allow for the original intent and scope of previous iterations of medically frail parole legislation, and I think all of us senators in here were here in the House when that occurred. This is a humane response to an increasingly aging and infirm corrections population, and I hope that it will yield a favorable response from the committee. Now, in full disclosure, I will note that there is a substitute to the bill, as originally written, that addresses a concern of the prosecuting attorneys of Michigan and also addresses a section requiring a medical facility to agree to take an individual granted medically frail parole that was inadvertently struck from the bill when it was written. I will now, I know that Kyle Kaminski from the Department of Corrections is also here, who'll be able to answer some technical questions, but I will entertain questions from committee members if anyone has them.
Thank you, Senator Geiss. And yes, I think we were in the Senate actually, because the bills were originally supposed to move in 2018, and then they moved in 2019, and it was a great bipartisan effort, and this is a great follow-up to that. Any questions from committee members? Okay. Well, then why don't we bring up Kyle Kaminski from the Michigan Department of Corrections.
Thank you so much.
Thank you very much, Madam Chairwoman and members of the committee. I am pleased to be here to testify in support of Senate Bill 599, addressing some deficiencies of the current medically frail parole law is a priority for the Department of Corrections during the current legislative session. The sponsor did a wonderful job talking about kind of the major changes in the bill. But to kind of go back to our experience since the original statute was adopted, it is true we've only been able to successfully parole one individual. That individual is still on parole today and has been quite successful. But ultimately, the definition of medically frail that's in the current statute really isn't functional once we got into practice. And so making some common sense changes that I think are still consistent with the original intent of the legislation, and while maintaining some of the key safeguards in the legislation, things like victim access to the parole consideration process, the ability for victims or prosecutors to seek leave to appeal a parole decision in these cases, et cetera. All of those are maintained in not only the statute, but the bill that is before the committee. But we will have the ability, I think, to judiciously apply this opportunity to more cases. The inclusion of the 12 months or less life expectancy, I believe, is significant because one of the scenarios that we found ourselves facing when we were trying to utilize the current law is that there were cases where the parole board had a sense that these were the types of cases that were meant to be impacted by the law, but ultimately individuals would not trigger the medically frail definition of not being able to stand, sit, or walk without assistance until very late in their illness progression. And at that point, there really wasn't time to take them through this entire process. So allowing the parole board to initiate this process when they receive that medical status report indicating that somebody does have a terminal condition of 12 months or less will give them the time they need to deliberate on the case and hopefully move it forward, and if it's an appropriate case, grant parole. So with that, I'm happy to take any questions from the committee.
Thank you for your testimony and for the work. I know this conversation started several years ago, and it's exciting to be able to take this up again. Senator Irwin.
Thank you, Madam Chair. Yeah, I want to ask just a little bit about how the timing usually works in these cases. I'm trying to get a better sense of how this 12-month piece might function based on what you just said. So let me walk you through a scenario and see if you can maybe complete the timeline just based on what would be typical through the process, right? I know that sometimes it's variable, but let's say there's an inmate, the inmate gets that terminal diagnosis, the medical professionals happen to say that their expectation is that this person has 12 months to live, and this person is fortunate enough to get that notice immediately upon having those 12 months, say for instance. They present that to the parole board. How much time is it going to take them between being made aware of that fact and when the parole process could reasonably be assumed to earn their release?
So quite honestly, it will be multiple months, and I'm happy to kind of walk through why that would be the case. So if healthcare were to make that determination, they would submit a medical status report to the parole board so that the parole board would be aware of the case if they weren't aware of the case previously. Parole board would need to provide notice not only to the incarcerated individual, but they'd also need to provide notice to the county prosecutor as well as any registered victims on the case before they can fully consider that case because the victim obviously would have the ability to engage with the board during that process if they chose to do so. There would be a hearing. It would not be a public hearing in these cases. It's essentially a standard parole hearing, meaning that the parole board member would interview the individual. They do that using Teams. So once we meet that notice requirement, the hearing could happen relatively quickly. Post-hearing, so the hearing is conducted by a single parole board member, but their panel partner would also need to review the case and vote. That would be relatively quick. Again, it could be expedited in these cases. But once we reach the point where the parole board grants parole, there's then another notice requirement in statute, which is we have to provide at least 28 days notice of that decision back again to any registered victims on the case before somebody is actually released. So I think in a expedited case with no unexpected scenarios, you're still talking 4 or 5 months probably, maybe a little shorter if everything lines up. But obviously there are factors that could actually make it a little longer in some cases. For instance, the prosecutor or victim could seek leave to appeal. That would then take the case to the circuit court and would certainly impact the timelines.
Got it. Thank you for the answer, and thank you as well to the senator sponsor for bringing this up. I think it's important. I really appreciate the work that's gone into it, but if it's not completely obvious from my question, my concern is that we've worked on these medically frail parole bills. There's been several iterations. Typically at the end of the process, what happens is that the process tightens the aperture so small that this time only one person could fit through it. I'm concerned about the timelines here, and I'm wondering if 12 months is enough, but I understand it's a balancing process, and I'll continue conversations with the sponsor, but wanted to make that point here that, even if someone does get that diagnosis, it's gonna take them a while to get out, and 12 months is a pretty short timeline given just the timelines within the process. Thank you.
I know we have a question from Senator Santana, but just to follow up on the timeline question, is the expediting, is that automatically going to be done for medically frail prisoners across the board, or is it just based on how much time is left?
I would expect it to happen across the board because ultimately the parole board's taking interest in these cases under this specific mechanism, understanding that medical frailty is a factor. So there's really no reason not to expedite each of these cases once they're identified.
Okay, great. Senator Santana.
Yeah, thank you for your presentation. I have several questions, Chair, if that's okay. On section 12 on page 18, it says the department shall not retain authority over the medical treatment plan for the prisoner granted parole under section 10, and the prisoner granted parole under subsection must have full patient rights at the medical facility where he or she is placed. So that information is redacted. So I just wanted to kind of get some clarification on why that is struck out. Are we saying that we are not wanting a facility to provide the same type of medical supports, or why is that redacted?
No, and I believe the sponsor, this was the section she referenced. I think this was somewhat inadvertent. So what is happening in the bill is that under the current law, the only option is for placement at a medical facility. So that language was placed into the statute to make clear that when you're placed at a medical facility like a nursing home, the MDOC can't exert control over your care. The bill expands to include home placement, but the scenario would be the same. We will not maintain control over somebody's care. Once they're on parole under this, they would be responsible for their own care or securing their own care. But we don't actually determine what their care plan would be.
Okay. Yeah, just to, all the sections that talk about the patient medical facility relationship would be returned. We just wanted to, when it was struck that it was only that they could only go to a medical facility as it's defined in the statute. Obviously, if someone goes, I shouldn't say obviously, if someone does go to a medical facility, we would still want them to retain those existing rights that they have as a patient. Okay. So it just needs to be, that's the section that we need to, that's going to be in the sub. That's going to be.
Oh, gotcha. Okay, perfect. Thank you.
No
Thank
problem.
you for the response. And then, Chair, if I may, 4 other states have gone to the idea or actually having their own nursing facilities to house those individuals who are incarcerated. Is there any conversation from the department on what that might look like for Michigan, if that is something that is an option for those individuals who are of that age where medical costs are increasing for the Department of Corrections?
Yeah, so we looked at that concept of having like a facility that operates outside of the MDOC but primarily houses people coming from the MDOC, like a nursing home. We looked at that relatively seriously back when the original statute was being going through the legislative process. I believe Georgia, there's a Northeast state, but I can't remember exactly which one, maybe Rhode Island, have this type of model. Ultimately, we actually did a request for information where we kind of tested the market to see what was out there. While I think there might be providers out there that would do it, we didn't find that we could sort of reach the critical mass of making a facility like that work in terms of having a steady patient flow. And so we went with more of sort of the model that's in the current bill, which is that they originally could be placed at any medical facility. Now with the option under 599 of home placement, which I think is a really important reform and a really key element of the bill, it probably further diminishes the likelihood of being able to run a standalone facility. The other challenge with the standalone facility is really a question around Medicaid. Medicaid can potentially pick up the costs of those facilities, but only if they are completely independent of the MDOC. So the MDOC can't create a facility, call it a nursing home, even though it's really more of a prison, and expect Medicaid to pay for it. That was one of the main challenges we ran into when we looked at it. So at the moment, we're not really contemplating that model. We really think the home placement model and then kind of a scattered site model for those that need a higher level of care is probably going to be the best model here in Michigan. But if we see the numbers develop in a way that a standalone facility might make sense, we'd certainly explore it again.
Okay,
If I-
and then
if
I
I may,
have
Chair.
one other question. If
If I can also add to that, there's from the standpoint of the loved ones, even if there were a separate facility that was specifically dedicated, and I think we might hear some of this from other people who are testifying who are loved ones of incarcerated or formerly incarcerated people, that it's still, there is still an additional burden put on the loved ones who might otherwise be able to care for their aged, medically frail, who would be parolees. So I think that that's an area where, in terms of the humanity side of things, where rather than creating, I don't want to say an excuse, but I'll use that language, to have someone still physically away from their family members who would otherwise want to have them or be able to care for them during their last days, it presents a potential for them to just stay in the system, which I think would be something that would be difficult for those family members.
And then my last question, juvenile lifers, Miller versus Alabama. Michigan is amongst 28 plus federal governments that have mandatory life without parole, at least some of the juveniles. And also in our state, we have about 30 individuals, at least out of the 125 that were not actual killers in multiple co-defendant cases. And so a lot of those individuals, obviously, we have talked a little bit about revisiting their cases here in our state. And many of those individuals are probably of the age where they are also potentially elderly or within the prison system. So I'm just wondering if we had this policy in place, would they also qualify for being medically frail so that they can also be paroled to go to these facilities?
So those specific cases would not be eligible because they're within the medically frail parole statute. There's an exclusion for certain offenses, including murder in the first degree and CSC in the first degree. So the felony murder cases you mentioned, as well as the juvenile lifer cases, would essentially be murder first cases. So there might be other means of relief, whether that's resentencing, commutation, et cetera, but this specific mechanism would not be available to them.
Okay. Thank you. I think we should revisit that conversation. Thank you.
I will say we did have that in the course of drafting this legislation. We did have that conversation many times, but there is also another package, as I think everyone on this committee knows, that addresses that particular population very critically, which I would also urge needs to be addressed.
And we'll make sure that conversation keeps happening. So, an important issue. Senator Johnson.
Thank you, Madam Chair. I see on page 21, it says a terminal medical or mental health condition resulting in a life expectancy under 12 months. Would that encompass anything else other than some type of dementia?
It certainly could. I think probably the common medical conditions, terminal conditions we see obviously would be a terminal cancer diagnosis, but also things like Parkinson's, multiple sclerosis, certainly dementia or Alzheimer's potentially. So we kind of see the full gamut of end-of-life conditions within the prison system. So it could cover really any of those.
Because I see Alzheimer's is really classified as a physical rather than mental health. So
It's an and, not an or an if. It's saying that Alzheimer's is being used in there as an example of one of the many myriad of possible diagnoses that could be given. It's not limiting to only dementia and Alzheimer's that's in the bill.
Alzheimer's and dementia are not considered mental health issues broadly. So they're considered just health issues. That's why I was curious what else. Is there a list of any of those things that we have, or is that not available?
We can certainly, the Department of Corrections would be happy to pull together a list of the types of chronic and terminal conditions that we deal with, and we can pull that together and share with the committee.
That we consider mental health issues?
Yeah, so I think the bill is drafted a certain way. I don't know that perhaps there's a little nuance missing in the bill or a little miscategorization in the bill. So, but we can certainly share both kind of the physical and mental health issues that we deal with for end-of-life cases.
Thank you.
I think from the perspective of LSB, possibly the reason they weren't all delineated is because the potential for missing one, say an emergent diagnosis, an emergent category. For example, there are ways we talk about some ailments that we no longer describe them in that same way. So I'll just use, for example, we don't say Asperger's anymore. We say autism spectrum, right? So I think if we were to prevent having to go back every single time there's a new classification of a disorder, they were broad in saying these categories of physical or mental ailments.
I see. I would be interested in the list just because, like, usually Asperger's wouldn't result in living less than 12 months. So I would want to know if that would count those kinds of things. I would appreciate it. Thank you.
There's a whole process, right, by which the medical team will actually evaluate and figure out what the life expectancy is. So it's not, there's going to be someone actually, evaluating folks.
Yep. So it would be initiated by the healthcare team. They do a medical status report, and actually under the medically frail law, there's also an ability for the prosecutor to request a second medical opinion, which would be paid for by the DOC and conducted by somebody who is not employed by the DOC.
Okay. Before we bring up the next, because I had a question. So I know in the Senate fiscal analysis, it says that there would be no fiscal impact, but I assume that there will be a fiscal impact, right? Because there are, based on the number of folks, which we may or may not have exact numbers on how many folks may be paroled each year that would no longer be under the supervision of the department. I'm assuming that would have an impact on your department budget, correct?
I think it potentially has an impact, but I want to be careful. I think that the impact is likely to be limited. We're still talking about a limited number of cases. And the other thing is demographically, the direction we're heading in terms of the age and frailty of the overall prison population is very challenging. So even if we were able to remove a small number of folks, there are probably going to be just as many, if not more, folks moving in that direction in terms of being older in prison. So we want to be a little cautious about making it seem as if there's going to be significant savings here. I think there's definitely cost. I don't always love the word cost avoidance, but certainly kind of it's going to help, limit how much costs increase in the future if we have this tool in these cases.
Okay, helpful. Thank you so much. All right, so next we'll have Jazmine Wells from Safe and Just Michigan. And as you all are coming up, we're going to go back to do the roll call. Madam Clerk, could you please call the roll?
Chair Chang.
Here.
Senator Schenk. Senator Voino. Senator Irwin. Senator Santana. Senator Runstead. Senator Johnson. Madam Chair, you have 4 members present. There is a quorum.
And I'll entertain a motion to adopt the committee minutes from the March 14th, 2024 meeting. Motion made by Senator Irwin. Without objection, the minutes are adopted. All right. John and Jazmine, thank you for being here.
Thanks for having us. I'm John Cooper. I'm the Executive Director of Safe and Just Michigan. This is my colleague Jazmine, who's our Policy Advocacy Manager. We are happy to testify in support of SB 599. We worked on the original 2019 law as well as several of its predecessors, which were sponsored by a string of House Republicans, I think starting with Joe Haveman, who's also here, but then Al Scholke and Dave Pagel. We, like others, were disappointed that we haven't been able to get more people out through this process, and we want to fix that. We think SB 59 is a really good step forward. I think there's other things we should be working on with respect to the aging prison population, the opportunity to address life and long sentences. But with respect to the medically frail population, this is a really good next step. And I want to turn it over to Jazmine to talk a little bit about why.
So as a few people have mentioned, SB 599, if utilized properly, will allow MDOC to transition both the responsibility of care for medically frail people to outside medical professionals and transition the cost of care from Michigan's general fund to Medicaid, Medicare, or private insurance. This savings could allow MDOC to invest in in-prison programming, vocational training, and reentry and support services. It could also help to alleviate current staffing concerns for healthcare staff and correctional staffing. SB 599 could provide better placement options for medically frail individuals. Prisons are not designed to house or treat medically vulnerable people, many of which often have complex and resource-intensive medical conditions. And the care of medically frail people is better placed in the hands of medical professionals or in medical settings that are better designed to meet the needs of medically frail individuals. Medically frail people, by definition, are terminally ill and or mentally ill and or physically incapacitated, and they do not pose a threat to the public due to their medical conditions. MDOC will have the discretion to determine who's eligible for parole and can mitigate concerns about a person's mobility by authorizing the use of a tether or other conditions of release if necessary. The problem will only get worse if not addressed. The overall cost for older incarcerated people are approximately 3 times as high as younger incarcerated people. And based on MDOC's 2021 statistical report, by year 2026, 1 in 5 people in MDOC custody will be age 55 or older. Older incarcerated people tend to have higher rates of disability than younger incarcerated people, and we have more information on page 3 of our written testimony. To conclude, SB 599 makes important changes to the original medically frail parole statute, promotes better placement options for medically frail incarcerated people, lowers costs, and does not raise public safety concerns, and appropriately addresses the problem of the growing aging prison population. Thank you.
Thank you both for your testimony. Any questions from committee members? All right, thank you. Up next on Zoom, we have Dr. Joy Obayemi. Apologies if I mispronounced that.
Hi, good afternoon. I hope you all can hear me okay. Good afternoon to the committee and to everyone in the room. I apologize for not being able to be there in person. But yes, my name is Dr. Joy Obayemi, and I'm a physician and a general surgery resident at the University of Michigan Hospital System. And I really appreciate the opportunity to testify on behalf of SB 599 and to share a bit about my perspective as a physician on this issue. In my work, I care for a wide variety of patients. I counsel patients in the clinic who are considering elective surgery. I see patients in the emergency room who need emergent surgeries, and I care for patients who are critically ill in the intensive care unit and approaching the end of their life. And I've also had the privilege of caring for many patients who are incarcerated, who seek care in our hospital system. And I firmly believe that every patient has the right to die with dignity, and that at the end of our lives, we are entitled to respect, compassion, and appropriate medical care, regardless if a patient is incarcerated or not. This is also an opinion that's shared by the AMA, the American Medical Association, which has previously stated that the continued incarceration of patients with serious or debilitating illness can constitute a violation of human dignity. So also to talk a bit about frailty. Frailty is a concept that we discuss in the medical setting quite a bit because it has a tremendous impact on patient health outcomes. One can define frailty as this aggregate loss of function across multiple organ systems. And as physicians, we determine frailty by taking a comprehensive patient history and by performing a comprehensive physical exam. And patients who are frail often have great difficulty completing their activities of daily living and are at great risk for injury. Having cared for many frail patients in the hospital, I have a sense of how precarious these patients can be and how often they require additional medical support. And I think it'd be incredibly challenging for frail individuals to receive the care that they need in the prison setting. They really are better suited for care in a home with medical support or in a care facility. And I think the proposed bill would allow for frail patients to really take advantage of the compassionate release policy that was previously passed. And these are individuals who have a hard time walking or standing independently, individuals who have terminal diagnoses, as has been mentioned, and have months to live. And it's important to note that these patients are generally very debilitated and pose very little threat to others in that kind of a medical state. So as a physician, I think that, we have a society, we have a collective duty to provide appropriate and equitable medical care to all individuals, particularly those that are incarcerated, who are, in fact, some of the most vulnerable among us. And I feel that this bill would allow us to really do that. So thank you again for your time and for the opportunity to speak today. And I'm happy to take any questions.
Thank you very much. Any questions? Senator Johnson.
Thank you, Madam Chair. I was wondering if you could tell me what you think might be a couple mental health conditions that would result in a life expectancy less than a year.
I think that's challenging. I think when it comes to specific mental health diagnoses, as has been mentioned, things like Alzheimer's, dementia, of course, those can be categorized as, being a general health condition as well as a mental health condition. So I really can't speak to what the writers of that section specifically had in mind, a little bit beyond my scope. But I will say that there are certainly mental health conditions in which patients are thoroughly debilitated. And I think, Parkinson's, multiple sclerosis, all of the ones that have been mentioned that have a neurocognitive component of debilitation could certainly qualify as being a terminal diagnosis if at a certain point. But other than what's been mentioned previously, it'd be hard for me to really know what the writers had in mind with that statement.
I see. I thought you might have seen some cases. I'm just not clear because all of those are considered just general health in all the medical books. They're not part of a mental health list. So I'm just kind of curious, trying to figure out what it could be. But thank you so much. I appreciate it.
No problem. I will say that having like psychoses and having kind of events like psychotic episodes that are frequent and not responsive to medications might be something that one could consider in that category. But yeah, a bit outside of my scope as a surgery resident, but just trying to give a good answer there.
Thank you so much for your testimony. Any other questions? Okay. Up next, we have Justin Counts.
Thank you, Madam Chairwoman and members of the committee. My name is Justin Counts, and I spent about 2 years working in Dwayne Waters Health Center while incarcerated across the street at the Jackson Correctional Facility. I saw things you would never see in a normal hospital. That's because prisons are not normally the place where people dying of cancer or struggling with dementia or who have multiple limbs amputated are supposed to be. If you're wondering how different it was from hospitals you're used to, let me share a few examples. I took care of several men and women in advanced stages of dementia. They would wake up each morning with no idea where they were, and why they were in prison. Many of them started their sentences as healthy and able-bodied people only to have their health deteriorate while incarcerated. Our hope is that people serving prison sentences can ultimately be accountable for the harm that they caused. But when they're having to be reminded every single morning of why they're even there, it's like they're being resentenced over and over and over again for something that they might not even remember doing. It's cruel. I ask you, does someone with dementia that advanced pose a danger to society? Or do we feel safer with them being locked up? I also cared for a man who had no arms or legs. They had been amputated while he was incarcerated. If he were in a nursing home, instead of completing his 5-year sentence for stealing, probably trying to feed himself, he may have been able to move to a different room throughout the day, maybe look out a window or even read a book. But because of his condition, he couldn't do any of that. He was in a prison hospital, which meant he couldn't even get out of the bed. He had to lay there all day, every day. Again, it's cruel. But what stuck with me the most is what happens when someone dies in a prison hospital, when there's no family to claim the body, particularly. It can take a while, 2 or 3 days, for prison workers to realize that there's no family left after they've exhausted all resources of trying to contact someone. It can take a while for the state to take possession of the body. During all that time, the body remains in the room where the person died, in that bed, for days. They would just put a piece of black bag over the window of that room for privacy, but everyone working there would know that there's a body there. Now, I understand that some people are going to say about this bill, what about the victims? Their victims didn't get to enjoy their last days either. But I have a few answers to that as well. First, most people that we're talking about and that I care for in that hospital were not killers. Most were people in there for things like retail fraud, driving under the influence, causing accidents, and also trying to feed their families by selling drugs. Ask yourselves this: do any of us want to be defined by the worst decision we've ever made? Should a part of our sentences for shoplifting or DUI be dying a torturous death of cancer without proper treatment that you would have gotten on the outside? I think we can do better. No matter what a person has done, we should not inflict cruelty as a punishment. Our Constitution says that we're better than that. Second, the people we're talking about paroling are not a threat. Like I said earlier, I cared for a man with no arms or legs. Another had lost his sight due to diabetes. If myself, was laying in that deathbed with stage 4 cancer, I would want to spend my last days with family. I would be coming to terms with my death, the eventuality of my death. I would be dealing with the pain of this diagnosis. I wouldn't have time to think about robbing anyone, not to say that I would have the ability to do that anyway. These are people who would go home to die for the most part, or people who would go home to a nursing home to get round-the-clock treatment that they need. We don't need to be afraid of these people. Let's pass this bill and make medically frail parole work the way it was always intended to. Thank you.
Thank you so much for being here and sharing your very important testimony. Any questions from committee members? Thank you again.
Thank you.
And then up next on Zoom, we have Maria Goellner, who's the Deputy Director of FAMM.
Good morning, and thank you to our hosts in the committee. As the Senator stated, I'm Maria Goellner, Director of State Policy for FAMM. I appreciate the opportunity to appear virtually this morning, and I appreciate all of your time. We know that you have so many issues before you, and we greatly appreciate your deep and thorough consideration of SB 599. FAMM submitted written testimony for your consideration today, and we are appearing in support of this bill, as well as Senator Geiss and the many Michigan state organizations working on this, including Safe and Just Michigan and AFSC. We are a nonpartisan national sentencing and corrections reform organization. For more than 2 decades, FAMM has advocated measures that allow for the safe release of medically vulnerable, aging, and dying people from our nation's prisons. Our members, which are nationwide, do include hundreds of families in Michigan dealing with a loved one's incarceration, and they want desperately for their loved ones to be able to come home in their convalescence and older years. Our system incarcerates people to deter crimes, to punish those who commit them, to protect the public, and to rehabilitate people who will one day return home. We believe that people should have a meaningful opportunity to leave prison if their continued incarceration does not serve any of those purposes of punishment. And for this population that we are talking about, old and extremely ill, it does not serve those purposes of punishment. Since 2018, FAMM has published comprehensive research into state compassionate release programs. We maintain a set of memos on our website that document every program like yours in the country, in all 50 states and the District of Columbia. In 2022, we graded those systems based on clear eligibility criteria and standardized, checklists of systems across the country based on best practices. Nearly 2/3 of the states flunked compassionate release. Michigan, unfortunately, received an F grade, and as you know, only one person has been released under the prior version of the law. Michigan received 33 points out of a possible 100 and needs some serious improvement on policy design and procedure. And we are very grateful and thankful that your Department of Corrections was here today publicly advocating for that as well. So our research and analysis informs our support of SB 599. The changes here are small, they are fairly technical, they are sorely needed. We commend this bill because it will remedy many of the issues that precluded the 2019 law from proper implementation. As you know, not only will it give the department the ability to put people in better and more suitable placements, it will also shift the cost of care from the general fund to Medicaid, and the state may be able to save significant tax dollars, as you heard, if this is passed and properly implemented. And it will also allow MDOC to focus on its core functions. Because of mandatory prison sentences, truth in sentencing laws, more people are serving long prison terms that cannot easily be shortened. Nationwide, our prisons are graying, and we're reaching a point where nearly a quarter of the U.S. prison population is considered geriatric by corrections standards. And as you may well know, corrections considers people older, elderly, geriatric at a much younger age than we like to consider ourselves in free society, because people typically go in with more serious issues, have had less access to quality care throughout their lives, less access inside, and also age at an unnaturally fast pace in an unnatural prison environment. And so when we talk about an elderly or geriatric age in prison being younger, that's not an advocacy standard. That is actually a correction standard. I want you to please know that and remember that. So we have nearly 9,000 people in Michigan now, prisons age 50 and over. And I really want to stress, and I hope that you remember, that these folks, statistically, according to every criminogenic study, data, analysis, are the highest cost to incarcerate and the lowest risk to public safety. Highest cost to incarcerate, lowest risk to public safety. Prisons also meet many challenges trying to meet these needs. They're not built to be geriatric units, dementia units, for people, with these serious medical and age-related needs. So many things for the prison that they have to think about in terms of ramps, lower bunks, grab bars, help getting to the pill line, help getting to commissary, help getting to the food hall, in and out of wheelchairs and beds, extra security staff to monitor someone 24/7 in a hospital. The list goes on and is compounded when you think about the understaffing that Michigan is facing in corrections, just like the rest of the country is dealing with also. So given the foregoing, we are very happy to support SB 599. I also want to offer as a resource that FAMM's General Counsel, Mary Price, who has studied, analyzed, and written the memos and report cards on every system in the nation, is on staff at my organization and is available to meet with you if you would like to learn more about Michigan's comparison to other states or best practices. I hope that this bill will be passed and implemented and that it will be a first step as we continue to strengthen this program in the coming years and decades in Michigan. And thank you all so much for considering this. Please vote yes.
Thank you so much, Maria. Any questions from committee members? All right. Madam Clerk, could you read in the cards?
All of these cards are relative to Senate Bill 599. All of them are in support. Kimberly Starr, representing herself, she also provided written testimony for the members. Natalie Holbrook Combs, representing American Friends Service Committee. Harvey Santana, representing Alliance for Safety and Justice. Sharmi Golson, representing Citizens for Prison Reform. Kay Perry, representing MI Cure. Carol Jacobson, Professor, University of Michigan. Joe Habeman, representing the Hope Network. Larry Smith, representing himself. He also provided written testimony for the members. And the last card, Tony Gant, representing Nation Outside. And that is all of the testimony cards in support of the bill, Madam Chair.
Thank you very much. Up next, we will take up House Bill 4940.